Hey folks, James Abrinio coming to you from Abrinio Law, your Northern Virginia personal injury and criminal defense law firm. Today I wanted to talk about a pretty interesting case that just got handed down um, by the Virginia Supreme Court dealing with governmental immunity against school boards. And the reason I wanted to address this is on more than rare occasions, get calls from parents that want to essentially sue the school for some type of injury to their child or some type of behavior that the child has been subjected to. And so a lot of times I have to explain to them that there are complexities when it comes to suing school boards and as well as school actors. That can make it very difficult to pursue these claims. And understandably, parents are very upset by that. And so I thought this case that came down recently, in fact, May 8th, it looks like, would be a good talking point, a good discussion point, just to give you a little more information, a little more details. Maybe maybe you're a parent that's looking to seek recourse for an injury to a child. Maybe you're just a local community member and concerned about or interested in the behaviors of the school board and what the school board can do in your local community. And this hopefully just provide a little more information about what the actual law is, or at least how it's being interpreted, and how the cases are being handed down. One of the things that I will say is, what makes law interesting is ever evolving. You may see a statute and it may look clear, but then a certain set of facts come down that make the statute more ambiguous, and that's the reason you need judges to interpret it. Now, there's a whole debate about, are judges creating law or not? That's for you to decide. But the reality is, as a practicing lawyer, I can tell you that statutes oftentimes need clarification because the facts of each case are always very different. What also makes this case interesting, tragic, is the actual facts about what happened here. And so one of the things that I think it highlights is, no matter how bad the facts are, if the law is being interpreted one way, the law will usually override the actual facts of a case if it is clear that the facts don't overcome the law. Good example, I can have, I deal with a lot of car accident cases. So if, let's say, you have a family member that was driving and was killed in a car crash, but they committed contributory negligence, which means they contributed just some portion of fault to the accident. No matter how badly that person was injured, even in that case where this example, this person tragically died, if contributory negligence applies, they are barred from recovery. So the family is barred from recovery if the court finds that contributory negligence applies. So the point being, no matter how bad the outcome, if the law bars recovery, the law bars recovery. And I get this question a lot when it comes to governmental immunity, because a lot of times people are just confused by it. They're not aware of it. And so I think this case is insightful. Whether or not you agree with the outcome or not, I think it's useful for a learning perspective. One other point that I would make is, when you have an injury claim against a county or the Commonwealth of Virginia, there are certain notice requirements that apply that act essentially, and practically speaking, in many ways like a statute of limitations. So if you're making a claim against a county, the statute, and I'm forgetting the actual statute, but there is a statute that requires that you give proper notice of your claim within 6 months of the injury. There's a caveat: if an insurer has actual notice, then that saves the claim. But there's effectively a 6-month notice requirement that you must provide, whereas for typical personal injury claims, there are 2-year statute of limitations. Let's say you were hurt in a car accident, you have 2 years to file a lawsuit. But if the defendant is a county actor, there may be this 6-month requirement. One question that I always treat conservatively is, well, is a school board a county actor? Is a school board employee a county actor? Because technically, the school board and the county are separate entities. So the way I've always treated is uh, I'm always conservative. I say, let's just not get into any issue. If I have a claim against a school board employee, then I will give the notice as if it's required. And what that notice requires is a whole different video in itself. But just a heads up, if you're either researching the law, claims against the school board or school board employees, uh, if let's say you're looking to make a claim or you're an attorney researching it, just be aware that there's a notice requirement, and so just don't get tripped up on that. So with that being said, I figured the easiest thing to do is just present this case so we can take a look at it together. So this is Newport News versus ZM. So it's a minor. So they used abbreviation, and it was brought by his father. This is an opinion authored by Justice Stephen McCullough, May 8th, 2025. So this is a very new case. And essentially, the way it comes down is the court finds that the school board is absolutely immune for lawsuits in the context of this case. Now, a quick summary of the facts, and this is not a long opinion. You can pull this off the internet. It's only 6 pages. A summary. You have a nonverbal autistic child. It does not give an age. I thought I'd try to find his age, but I didn't see the age here. It attends Center for Autism at Kiln Creek Elementary. This is Newport News. His father ended up filing a suit on his behalf. What is alleged here is that employees of the school board struck him in the face, apparently with a wet sock. Didn't provide details of where that wet sock came from. They did, and they told him twice they wish they could whip his tail. And concerningly, I guess the child removed his own pants and diaper, and then the employees allowed him to leave the school bus without any clothes covering the lower part of his body. Now, one thing that is unclear from the opinion is what exactly the roles of the employees were. Was this a bus driver? Was it oftentimes there's bus assistants that they're just meant to be monitoring the children. Sometimes somebody's just catching a ride. I don't really know. Presumably they were on the job when this happened, but nevertheless, they were school board employees. So just tragic set of facts. I mean, you can't really get more concerning this. And also, there was an allegation the employees insulted the minor, saying that he was acting like a, quote, animal and monkey. It's just horrific facts there, and really concerning behavior. I can't say anything, we'll talk about the law here, but hopefully somebody was fired and there was serious action taken to make sure this doesn't happen again. Now, lawsuit was brought for $15 million, and essentially the school board responded saying they filed a plea in bar. And essentially a plea in bar is essentially saying, look, let's assume these facts are true just for purposes of argument. You don't have a legal leg to stand on because we are immune. And I guess at trial in the circuit court, so there's levels of trial courts in Virginia. Here, if it was a $15 million suit, the trial court would have been the circuit court. That's like what you see on the movies with you get the jury. But this was a pretrial motion. The circuit court essentially denied the school board's claim of sovereign immunity, and the school board appealed it. Let's see. Well, I guess it denied the plea in part and granted in part. And what happened here was, sorry, I'm just reading a little more. The circuit court denied the plea with respect to the claims of simple and gross negligence against the school board. However, granted a plea on the question of punitive damages holding sovereign immunity foreclosed. such damages, and the school board filed an interlocutory appeal. What that means in plain language is the court said, the circuit court said that school board, you don't win on this issue. You got to go in front of a jury, and then the jury can decide the facts. And then the school board was able to file an interlocutory appeal, essentially allowing it to get up to the appellate court prior to trial. So that was essentially a quick way to get there. And ultimately, this Supreme Court denied that trial court's decision. Now, in its opinion, you're going to get a little bit of history. Here, they noted that because this is a legal issue and not a factual issue, it's de novo. What that means is the decision by the trial court is not given any weight. This is a decision that the Supreme Court is making on what the actual law is. If the trial court had made some type of factual finding, usually the appellate court will give some discretion to the trial court. Let's say, for instance, was a witness credible, or there's sufficient facts, or should a certain part of evidence have come in. And the reason the appellate court gives some discretion to the trial court is it kind of makes sense. Whether or not somebody's credible or not, oftentimes it's hard to read from transcripts. You got to see facial expressions. You've got to understand changes in tone of voice and all these ways that we communicate as human beings that are not seen on a page. Whether or not evidence should come in, the court is given discretion on, because they have the real context of seeing what's going on in the room at the time. So the appellate court is going to give discretion. But when it comes to the rulings of the actual law, what does the statute say? What does governmental immunity say? The appellate court here, the Supreme Court, they make that decision regardless of what the trial court did. And in doing so, they go back to the Federalist Papers. Here they quoted Alexander Hamilton, Federalist 81. And for you history buffs, you know what that is. But for the layman, Federalist Papers were essentially documents written as the country was considering the United States Constitution, whether or not it should be adopted or not. And the Federalist Papers were essentially arguments of giving context to why the Constitution was important, and certain aspects of that. Obviously, this is a 1,000-foot view, but I would recommend you go back and take a look at that if you don't know a whole lot about the Federalist Papers. And Alexander Hamilton, I hear there's a great show with him. But they quote him here, quote, "It is inherent in the nature of sovereignty not to be amenable to the suit of individual without consent. The ancient doctrine of sovereign immunity, while often controversial, is alive and well in Virginia," end quote. And then they quote Messina v. Burden, which I'm sure is also quoting that as well. And it goes on, "Absent express statutory constitutional provisions waiving sovereign immunity, the Commonwealth and its agencies are immune from liability for tortious acts or omission of their agents and employees." And then it's quoting additional cases. And so what sovereign immunity really is meant to do, it's meant to allow our government to operate without being essentially sued out of existence. Because if a government can just be constantly sued, money and resources are going towards that. And so, I get the argument for governmental immunity. From an intellectual standpoint, as a government major, I understand that. But, when I look at a case like this and you see horrific facts, as a human being, as a parent, I'm thinking the government, our school board, is immune for behavior like this. It is concerning as a human being, I'll tell you that. But again, the goal, the purpose of these opinions are to interpret what the law is. And we're going to be delving into some statutes. And so here, this is page 3 of the opinion. Essentially, the way it works is governmental immunity applies unless the General Assembly waives it. And what that essentially means is our law body, our law legislative body down in Richmond has to essentially make a statute to say, look, we're going to be waiving immunity in certain instances to allow for claims of negligence and gross negligence, and those are loaded terms, but we'll keep it simple for right now. And here there's a specific statute that was being litigated on point. It's Virginia Code 22.1-194. And there it says liability of a locality or school board owning or operating a vehicle. And this makes a lot of sense because school bus accidents happen, car accidents happen, and I haven't looked into the legislative intent behind how this statute got passed, but from a common sense standpoint, you want to make sure that when your kids are getting onto a bus, if negligence happens by the school bus and they get injured, you want to make sure that there's coverage there. Caveat and public service announcement, yet another reason why you want to buy a lot of car insurance, because if you buy protection, particularly underinsured motorist coverage or uninsured motorist coverage, and your child is injured, they may qualify for protection under your own policy as well if it proves that the local school board's car insurance is not sufficient. And what am I talking about here? It says and we'll read the statute, in the case of locality, a school board is the owner or operator through a medium of a driver, and it goes on, of a vehicle involved in an accident, the locality school board shall be subject up to action, but not beyond the limits of valid and collectible insurance enforced to cover the injuries complained of. What that means is the school board is going to adopt or going to purchase coverage for their school buses. And this waives immunity, even for simple negligence, meaning that the driver just messed up to whatever that school board chooses to purchase as far as auto insurance coverage for accidents. And one thing that's always frustrated me about this statute is it essentially says the school board shall be subject up to action up to, but not beyond the limits of valid and collectible insurance. And what that means practically is a school board can choose to insure itself up to, the minimums, $50,000 right now as we sit here today. And let's say your kid is catastrophically injured. They've only purchased $50,000 in coverage. That's a small policy. And here at my firm, I'm constantly telling people, buy $1 million of underinsured motorist coverage if you have any opportunity at all. It's only a couple $100 more a year. Frankly, if anybody from the school board is watching this, buy more auto insurance for your students. It would be worth the investment if somebody was badly injured. And I get that you school board members, because of the statute, don't have a whole lot of incentive because it essentially immunizes you for anything over those limits. But as a parent, and I'm sure that you guys, if you're on the school board, likely are parents or have been parents of students, you would want protection for your children. And if you're doing that public service, you probably want to protect the kids. Look into getting better insurance policies because this statute only allows for claims up to that limits of coverage. Okay, so this is a statute we're talking about here. Now, this statute typically deals with straight car accident cases. So let's say your school bus rear-ends somebody and a child is injured and they suffer a broken bone. That's what we're traditionally talking about, because when we're talking about in the operative language is vehicle involved in an accident. Now, what makes this case interesting, tragic albeit, but interesting, is it highlights what involved in an accident means. And so going on page 4 of this opinion, you see where the school board argues why sovereign immunity applies here. And it essentially says it's only waived when the vehicle owned and operated is, quote, involved in an accident, end quote, and insurance, the other is coverage must be available. Now, interpreting this, the Supreme Court applies language that is pretty traditional. There's nothing I think this is a, again, I disagree with the outcome, but I understand the interpretation. I understand it. I disagree with, but I understand it. Interpretation, and here it says, interpret the statute we seek, this is the Supreme Court, to effectuate the intent of the legislatures as expressed by plain meaning of the words used in the statute. Accordingly, we apply plain language unless the words are ambiguous or such application would render the law internally inconsistent or incompatible of operation, end quote. And it's quoting Carter, which is another case that you can look up. It's essentially saying that where the legislature uses language, we got to look at the language and see what it plainly means. And if it's easy to understand without looking beyond that language, we're going to go with that language. And here, involved in an accident traditionally means a car accident. They go on. However, we conclude the waiver of sovereign immunity does not apply because in this instance, the bus was not involved, quote, was not a, quote, vehicle involved in an accident. They go on, the term accident can be defined in many ways. Vehicular accident, meaning collision between two vehicles, a collision between a vehicle and an object, vehicle running off a road, and it goes on. And it goes on to essentially say, in this case, we need not establish the outer reach of what the term accident might mean, because the allegations here, the plaintiff was struck, insulted, and allowed to leave the bus partially enclosed, do not plausibly establish the prerequisite of a vehicle involved in an accident. The school bus itself was not involved in an accident. The plaintiff's injuries do not relate in any way to the way the school bus was being operated or the process of loading or unloading passengers. Instead, the school bus was merely a situs of the alleged tort. In other words, the actions or subject of the complaint may have happened on a bus, but they did not involve the bus as a vehicle. And then they go on. There was a case, Wagner, where a school bus accident happened where I guess a child was being let off at a crosswalk, and then the kid was hit in while walking, and there the court was more apt to say that it was involved in an accident because it dealt with an actual car accident, even though it wasn't technically the school bus being involved in an accident. Now, what I will say is, and sorry, I'm just digesting this a little more. What I will say is, being involved, first of all, in an accident, I think, first of all, you need to look at the term involvement. And my view of this is I would like to see more factual understanding of how the vehicle itself played into the role of these allegations. So, for instance, if the injury victim here, if the child here is only interacting with these employees because the employees are specific to the school bus, like I said, either a driver or a school bus assistant, in my view, clearly the bus was involved, because but for being in that location, they wouldn't have had this interaction. Okay, that would be an argument that I'd probably make contrary to that. What is an accident? I'd want to know exactly more details about what was the surrounding circumstances, about the child being essentially assaulted, arguably not, but hit in the face. Maybe, and this is where let's go look at the facts. A little more detail. Employees struck him in the face, apparently with a wet sock, told him they wish they could whip his tail. I don't know. Maybe they intended to strike him in the face. Maybe it's one of these things where these jerks are behaving in such a way where they're just trying to tease him and accidentally hit him in the face. I don't know. But those are more facts that I'd want to take a look at to see exactly, is this an accident or not? Now, is this a car accident? No, absolutely not. Is it arguably an intentional tort? Sure. But I would want to know exactly more details so I could get a better sense of where we're going with it. And so hindsight is 2020, obviously, but it would have been interesting to have more of those facts to see what could have been argued. And the goal here, if you're the plaintiff's attorney, is trying to get it to a jury so a jury can decide. Because it's obviously if it's kicked out on a plea and bar, then you're never getting to a jury on it. So, but it's, I understand the court's reasoning, but I'm a plaintiff's attorney. I'm obviously biased. And I'd like to see more delved into those issues about how they came, the interaction of being on the bus, as well as the actual contours of how the actual physical contact occurred. And, also how did the child come to be undressed? Maybe they didn't see that the child had done that. I don't know. Again, these are all questions that could be that maybe there's answers out there, but the case has been decided, so we won't know, but something to think about. Now let's go on, because that's not just the end of the case. And give me just a moment. I want to get back to where I'm at. Now, another argument that the plaintiff argues is the school board is not immune when it comes to gross negligence. And the court then lists a series of, I think, important cases where these cases all talk about immunity as it relates to the individual employees. So usually you'll sue both the school board as well as the employees. And the reason being is you're worried that the court is going to kick out a claim against one or the other, and you don't want to lose everything you got. And so the cases it's addressing here is claims of gross negligence against the actual employees of the school. And I think the most well-known, at least the one that I'm most aware of, is Burns v. Gannon, this 283 Virginia 657 2012 case. There is a statute that protects teachers and provides them immunity, but not in cases of gross negligence. The court, first of all, that case was interesting in that it showed that even if the school board itself has immunity, I'm not sure if it was litigated there, but the point here is even if the school board is immune, you can still go after the employee. And if there's insurance there, then that may be enough to get it done. Because one of the things that, at least if you've got an injury case that you're concerned about or a family member's concerned about, I tell people this all the time. While obviously we want to right your wrong, we want to have closure, we want to have apologies and all those kinds of things. At the end of the day, if you're bringing an injury claim, our job is not to fix your injury. We can't do that. Our job is not to get apology letters oftentimes. Our job is to try to put compensation in your pocket. So if there's coverage for an employee and you can get all the money you need from that employee, even if the school board is immune, that may be enough, right? I'm just trying to put money in your pocket if I'm representing you. And frankly, my advice is I don't care where it's coming from. I'm just trying to get you to be able to live your life and be compensated for your injuries, be compensated for this job that you never asked to be put in by being injured or family members being injured, and try to move on with your life. But Barnes v. Gannon's was an interesting case. Because there was, I think, an assistant principal. He was told by a student or learned through the grapevine by a student that other students were going to attack him. He said he would alert security and take proactive measures. Ended up just, I guess, filing in the cabinet, not doing anything. And tragically, the kid was violently assaulted and suffered significant injuries. And what the court ultimately said was, that may have been gross negligence and there may be liability against the principal. And so ultimately, I'm not sure what happened in the case, but the case was allowed to go forward. And what the court is saying in this case is, here it says, although the government employees are not immune from claims of gross negligence, the school board itself is. Flip that around, what that means is here the school board employees for gross negligence were not immune, where you could show gross negligence. Now, first of all, and I think that I want to say I saw somewhere in here in the opinion that ultimately the case was settled against the employees. So the thing that was remaining was against the school board. But maybe I'm misreading that. That actually might have been from Gannon and Burns, not this case. But here, the court said that it's possible to go against the employees. Now, where the issue lies, however, is what is gross negligence? And that is a topic for another video that I probably want to shoot at some point, because gross negligence under Virginia law is very, very difficult to reach, effectively impossible. And there is a case arising from the Boy Scouts of America, I believe, where essentially it was a wrongful death case where a scout was allowed to cross a pretty big river or water, moving water source, despite the scout leader knowing that the child couldn't swim, allowed him to try. I think the scout leader was ahead of him. He tries to swim, gets caught up in the current, ends up dying. And the court said, well, that's not gross negligence because he made an effort to try to save him after the injury, after the kid was caught up, and therefore that's not gross negligence. So whether or not this case ever gets to gross negligence or not, I don't know. That standard in Virginia is just so high. So I don't know where this goes ultimately. And that's one of the frustrating things from the public standpoint is how cases like these end up resolving at the end of the day. A lot of times you never know because things get settled and things like that. And you just don't ever see the end of the story. But I think the case is definitely important for purposes of understanding or getting a better sense of what governmental immunity is as it relates to the school board, what it is in general. And again, the notion that you can have horrific facts and the court can still find it against you. And you can disagree. I, as a lawyer, can disagree with the holdings from a policy standpoint, also arguably from an interpretation standpoint. But at the end of the day, the Supreme Court of Virginia gets to decide. And if you ultimately don't like these outcomes, and I'm sure they would say, you got to go the political world. You got to go and have the legislature change the rules. You've got to contact your local senator. You got to contact your school board. For instance, I'm giving you an example, get your local school board to get more auto insurance in case there's a car accident. Another thing could be contacting your legislature and saying, look, we disagree with this opinion. We don't think governmental immunity should apply for school boards outright. And absolutely, we think there should be instances where the legislature should limit that because we want there to be some type of consequences on the school board if certain things happen. We disagree with the holding of what gross negligence is, for example. You may read that Boy Scouts of America opinion and think it's horrific. And frankly, I'm very concerned about that opinion. But there are things that we can do, or things that you can do as community members to let your legislatures know, look, we want opinions. We understand the court's opinions here. You could absolutely read this opinion, and I can see where the justices are coming from in this opinion based upon what the law is. But ultimately, our legislature can make the actual laws change. And so, one thing that I've tried the best I can is to focus locally. There's a lot of stuff going on in DC nationally that are truly concerning, truly concerning, that I'm losing sleep over, as I'm sure a lot of you are. But I will say, when it comes to local rules, your local community, your state, or commonwealth, you can have a real impact if you care enough to reach out. We have a lot of good legislatures that care, that when they are supported, can do a lot. So that's all I would say is, you know, um, hopefully you learned from this video a bit. If you disagree with it, take some action. And I'm saying this to myself as well. I'm trying to make my own efforts, but just again, my heart at the end of the day goes out for this family. Just horrific set of facts. I'm sorry. Not that they'd ever be watching this, but if they ever did, I'm just horrific to have a child go through that, much less somebody who is autistic. Just horrific. Um, um, and I always tell people, look, things like this are above my pay grade. If I could do something about it, I would. But for the public, at least you can understand more about where the court's coming from, what the law says, and I think in order to change things, you have to understand it first. So hopefully this was useful. Feel free to comment below. Feel free to disagree with me. Feel free to say, James, you're an idiot. Feel free to take action. And if you have questions, just reach out. Hopefully this was useful. If it was, make sure to like and subscribe. I'm going to keep doing these things. And yes, this video probably could have been shortened to 10 minutes, but what folks who don't do YouTube don't know is a lot of the time comes into editing. I'm just trying to get information out to folks as quickly as possible. And honestly, just trying to run a full-time firm and helping read law can be time consuming. So, sorry it took long, but thank you so much, guys. I wish you the best. And